Okay, team. It is 1 o'clock, so I'm going to go ahead and start the meeting. I feel like crud, so you guys get to listen to me be all sniffly and stuff. But it's December 29th, 2017. This is the 1 p.m. notice of public meeting for Child Support Guidelines Committee. And I will start by taking roll call. Kathleen Baker.
Present.
Karen Cliff. Ellen Crecilius.
Present.
Senator Farley. Assemblyman Fumo. Judge Hoskin.
Here.
Nova Murray.
Here.
Assemblyman Pickard.
Here.
Judge Robb. Not present, but I believe she will be with us any minute. Senator Roberson. Same thing. Joe Sanford.
Here.
Judge Shirley. Justice Stiglitz. Kim Surratt, I'm present. And Don Throne.
Here.
All right, we have a quorum. Do we have a phone line? We should have a phone line going, right? Yes. Is there a noise that, oh. No one's called in, that's why. Yeah, if they call in, then you can probably hear that crackling noise. So we will start with public comment. Do we have, if we have anybody that wants to give public comment, it is restricted to 3 minutes per person. I will time each person that would like to give public comment. Do we have anybody in Las Vegas that would like to give public comment at this time?
We do.
Oh, okay. Hello, sir. If you could start by giving us your full name, and if it's a difficult name, if you could spell it for us, that would be helpful. And after that, I will start your timer for 3 minutes. I do get to be nice and rude and cut you off at 3 minutes, but that keeps our meeting going. Okay, sir? I need you to turn on your mic. If you could, there's a button so we can hear you.
Okay, there we go.
There we go. Okay.
We have a couple other people that should be showing up too. That I think they're running a little bit late, but I would like to bring up some issues with in regards to child support. So, yeah, I would like to begin. Thank you for allowing me to speak today and for this child support hearing review of the guidelines. My name is Michael McDonald.
There we go. Thank you.
Yeah, Michael Mcdonald. I am an advocate for family law reform. I work with a few groups, Restoring Freedoms, Family Civil Liberties Union, Veterans in Politics, and Reforming Family Courts. We've been doing a lot of research on different things regarding child support, custody issues, and there's a lot of things that need to be addressed. And one of the things is partly due to child support regulations that's incentivizing stripping of families and separating families apart due to money. So a lot of money concerns, a lot of greed that's happening, especially in regards to custody. So I'd like you guys to really address that issue in regards to looking at our IRS statutes with regards to Title 42, Section 666, which is the Child Support Enforcement Act. I would like you guys to review that, repeal that possibly with our IRS statutes, as for currently it's being used to strip parental rights from parents based on how much money they're making or the percentages. So in other countries, I'd like you guys to also look into the other countries, how they're doing it. In other countries, they do a flat rate. It's a $200 per month or whatever the national average is per child. And then it also has a set standard of joint physical custody. So there isn't an incentive to fight over each other's children, and causes so many social issues: anxiety, depression, mental illness, criminal history, drug use. All this stuff is stemming from the child support and through our family court system. So if you guys could, we have a lot of research that we have that I believe I emailed it to you guys. if you guys could look into that research in regards to just changing the percentages, which I know you guys are focusing on. But I'd like we should also do the enforcement piece, the enforcement of parental involvement, not just enforcement, such as especially taking the licenses away of litigants or parents. How are they supposed to go to work? How are they supposed to provide a living? Most dads and moms aren't trying to be deadbeat parents. They're trying to make a living. They're trying to take care of their children. But when you have a system that's incentivizing stripping their own children from each other, it causes so many issues. So I'd like you guys to review that. Maybe if there is a means for child support, do a flat rate or something, put it on a card or something if that's a means. Or even in our days, our child support laws haven't been changed since the 1950s when a woman or man would stay home with the children and the man would go provide or whatever. It's time for change for this. And in order to go and strip parents and take that away, I'd really like you guys to look into the reasoning behind that. And we'll look at the effects. I mean, we have a lot of social issues and all these.
Thank you, sir. It's been 3 minutes. I appreciate your time.
Okay. All right. Thank you. And if there's a way I can email you guys some more stuff, I mean, I think you guys reviewed that. So thank you.
Sure. If you'll stay there for just a moment, sir, I'm going to ask the committee if anybody has any questions for you before you stand up and leave.
That 3 minutes was fast. Sorry.
It does. It goes really fast.
Yeah.
That's why I'm giving the opportunity for the committee to ask you questions. All right.
Yeah.
Seeing none, each agenda has information on it on how to submit written public comment to us and information to this commission. Of course, if you've submitted it already, I don't recommend submitting it again. What has been submitted to us is posted on the website, on the DWSS website for this commission, and it's listed in our exhibits of information for the commission.
Okay, and I'd also, you guys look at Title 4D too and defunding that. So thank you.
Okay, thank you, sir. Okay, do we have anybody else in Las Vegas that would like to give public comment?
No, Madam Chair.
Okay, thank you. Anybody in Carson City that would like to give public comment? No? All right, anybody on the phone that would like to give public comment? Hearing none, we will close that agenda item and move on to agenda item number 3, which is approval of meeting minutes. We have 2 separate sets of meeting minutes that need to be approved. And the first being from November 17th, 2017. Do we have a motion to approve those minutes?
So moved.
And a second?
Second.
All in favor say aye. Aye.
Aye.
Anyone opposed, say nay. Motion passes. Then we have the minutes from December 13th, 2017. Do we have a motion to approve those minutes?
Madam Chair, just a quick question.
Yes, sir.
Are we, was there a transcript made or intended to be made or a video made of the presentation? I went online to look for it and I didn't see one, but maybe I missed it or I looked earlier than. I don't know. I was assuming that the meeting last time was recorded and I wanted to see Mr. Schoen's presentation, but I couldn't find it. So I was wondering if there's a transcript that should maybe be included in the minutes or if there's another means of getting that.
Nova Marie, for the record, the meeting, or that meeting was recorded. We're having difficulty figuring out how to get it out to the public. It was in a different format than the format we get out of LCB. So we are working now to look at potentially making it into a YouTube video. We aren't exactly sure, and I have staff reaching out to the university to find out if it comes in a different format or whether or not we have to get somebody to convert it. So as soon as we can, we'll get it out there.
All right, thank you. Then with that and with the expectation I'll be able to look at it later, I'll go ahead and move to adopt the minutes.
Okay. I'm sorry, we have an extra comment from Ms. Murray.
I have to make this for the record. Nova Murray, for the record, we may be able to forward that to you and see if you can open it from your particular computer before we're able to get it out to the public. because you were in attendance, I don't see that as being an issue. So I'll go ahead and have staff forward that to you. If you can or can't open it, that'll be at your end, and then we'll figure out how to get it to everybody else.
Very good, thank you.
Okay, do we have a second to approve those minutes?
Second. Second.
All in favor?
Aye.
Aye. Opposed?
Aye.
Hearing none, minutes pass, motion passes. All right, we'll close that agenda item and move on to agenda items underneath number 4. Number 4 being just a header, which is the breakdown of the child support guidelines review and the recommendations within. I am going to go slightly out of order and jump down because I want to wait until I know Judge Rob's on the road and she drafted some of those changes for 4A. So I do want to have us just go ahead and skip for right now to 4C. Since the meeting that let me preclude that with what 4C is. 4C is discussion and recommendations as to how to address the treatment of incarcerated parents or parent recently released from prison. We had sample language that I provided to the committee that really was only sample language taken from California with the intent that we edit it down to what is appropriate for Nevada. But since this has been provided to the committee, we have not had an opportunity in any of our meetings to actually address that language and get to this agenda item in quite a while. So one of the conversations I wanted to open on it was our public comment that we received during the last meeting from DeAndrea Ceccarelli. And the input, we also received some input from Bryce White specifically on the issue of incarcerated payers. And the language that we started with that we haven't edited yet from California included self-adjusting provisions that I wanted to open up for discussion with this committee because we just haven't dug into this since we wrote it up. Do we have anybody that wants to comment on the incarceration language?
Nova Marie, for the record. I'd really like to get with Colorado and look at some of the options they have in Colorado. We do have some of the incarcerated individuals do have employment while incarcerated, and there are orders that are being paid out of the prison. So I'd like to look at some of that and see if it only happens to a really small percentage of the population in prison, or if it happens to certain levels of prisoners in prison. I'd like to look and see what we would be affecting if we really knew there were money there and we could go after it. Would that change our mind about how we do an order like this? So we could talk about the language today, but I'd really like a chance to, I know Colorado is one of the big ones that pushes getting the income out of the prison versus other ways they have income. So they would obviously have income from potentially RSDI, they might have income from some annuity or some retirement someplace else, but they're also working in there. And I was trying to reach the head of the prisons. I have a couple contacts. Everybody's been gone over the holidays, including myself, so between playing tag, I haven't had a chance to talk to them, but I'd love an opportunity to see what that brings for us. Because like the gal that gave the public comment, if there were money in there for her to have, this would kind of maybe impede it going the other way. She'd be fighting against the automatic adjustment versus being notified to come in and start the process. So I'm just not sure if we have all the facts.
Crickets. Anybody?
I have a question, not to fill the space, but I apparently don't have the document. Can you tell me when that was sent so I can go back into my email and look?
Sure, and I know it was put out as an exhibit at one of our meetings. Actually, the easiest place for you to find it,
Oh, so it's minutes.
Yeah, it's Exhibit 1 to the minutes from November 17th.
he's looking at what?
Further back. Back to November 17th.
It's November
Yeah, that's not the document that I actually drafted up where I kind of peeled some of the language out of California.
I don't have
If
that.
you go to the DWSS website and you look at our list of materials for the Child Support Commission, it is listed there. That's probably the easiest place to find everything at this point. But it does have a title at the top that says Suspension of Order for Support of a Child, Exceptions, Resumption of Obligation, and Administrative Adjustment. That is purely language that was California's language. It's not edited down for us yet, other than I stripped out things that we specifically stated in our meeting that we wanted stripped out, like the domestic violence exception, and a few other things. But what we did, part of the discussion, or where I was going with this, was that we didn't have an in-depth discussion about the self-adjusting language. Just that this was not going to be our final language, but that California was a good place for us to do our initial language grab from and utilize it for a starting point for us. So the starting point's been out there. We just haven't had an ability to get to it. And I think based on our public comment at our last meeting, and now what Ms. Murray's saying is that I think it takes some discussion for us to dig into it. I would absolutely agree that if they're working in prison or there's income from any other source, then child support needs to continue on that. The biggest part that the feds required from us is that we not impute income based on the incarceration. That incarceration is not grounds for automatic imputation of income. That doesn't exist. Now, if income actually exists, that's different. Thoughts on, we had gone down a little bit down a rabbit hole of discussing these self-adjusting orders from a 4D perspective of they're in prison and an automatic adjustment. I don't know, but we didn't make any final decisions on that. At least I don't feel like we did in our prior meetings, unless anybody's got a different perspective on that. Mr. Sanford?
And this is Joe Sanford for the record, and I'm just trying to recall of the base where we were at the last time and what we wanted to do moving forward, and what was currently being done, I think, was part of that. And as far as the 4D program is concerned, obviously the guidance from the Fed is everything's going to have to be based on ability to pay. And so, as Ms. Murray suggested, and if there is a significant ability to pay or actual ability to pay some amount above zero, I think we would want to look at that instead of just setting them to zero. My understanding is it was the current practice in Las Vegas to have sort of a review or process to review cases that there was an incarceration and they were setting them to zero, but I don't believe it's currently being done automatically, and that was part of the desire, just from sort of an efficiency process where, to my understanding, if there isn't generally an ability to pay except in limited circumstances, that it would start at a zero order or being likely to be set at a zero order unless some evidence was shown that a particular inmate was capable of generating some income. And so I think that was where we were at moving forward. I'm happy to, I think, discuss that further if the evidence indicates that it's not just a very minor portion of the prison system that would have that ability to pay.
Nova Murray, for the record, I agree. I would also like to think about maybe putting programs in place where we talk with the prison and see if, because I don't know what it is. I don't know if it's 0.5% or even less than that, or if it's greater, but maybe there's a way to put programs in place to enhance that, to bring it up to a notable amount. I don't know until I talk to them, but I'd really not want to put this in place in the next session and try to come up and fight against it so we could put a program together if possible. So maybe the more educated we are, we could push this out a little bit and know whether or not options are available, or they might not be. The prison is the best place to start.
Keith Pickard for the record. I don't know what leverage we have or what options we have with respect to the federal guidelines or the federal regs and how they will interact with the funding and that sort of thing on this point. In other words, I don't know if we don't adopt the federal standard, do we lose funding? If so, I think that will impact our decision. But ultimately, and I guess it was brought up in public comment last time or alluded to, but one of the things I've been hearing lately is that if we do go to an automatic suspension of an obligation, it becomes problematic for the families who have to who were relying on child support, and now the individual has done something to it's a voluntary act that had got him incarcerated. At what point does the family then get made whole? There's got to be some consequence attached to the crime. And it used to be that arrears, once they were released, then they could work towards making that recipient parent whole. I recognize that there are going to be some necessary suspensions, I'm thinking, or suspension of rules. I'm thinking specifically the suspension of driver's licenses and professional licenses if they exist after the incarceration. Those things would have to, or would make sense to keep in place in order to keep the person employed and earning money. But I hesitate in going straight to zero when the person ultimately got themselves in that spot to the detriment of their children.
This is Kim Surratt for the record. To the extent that the federal language puts any mandates on us, I think it's just on the imputation part of it, that you can't use the fact of incarceration to impute income that doesn't exist, that isn't there. But if they have income, I don't think it's meant to counter that. Based on the language that we have from California, if you look at Section 2, it's every money judgment or order for support of a child shall be suspended by, now this is that part that I think we need to be looking at, shall be suspended by operation of law for any period exceeding 180 consecutive days in which the person ordered to pay support is incarcerated or involuntarily institutionalized, comma, unless the person owing support has the means to pay support while incarcerated or involuntarily institutionalized. Incarceration or involuntary institutionalization shall not be treated as voluntary unemployment, and income shall not be imputed to the person who is incarcerated or involuntarily institutionalized. The last sentence, I think, is the extent in which the federal government puts a duty on us that's tied to our funding from the federal government. At least that's my understanding of it. Ms. Murray's shaking her head yes, too. That last sentence in number 2 is what's the critical part. Part of our discussions in this commission were, I don't know if that goes far enough to tell us what really to do with incarceration. Obviously, in section number 1, there's some definitions. We need definitions of what is incarceration, what is suspension. We had talked somewhat at length in this committee about the 180 days and using that 180-day mark. But there is still a caveat in here that says, unless the person owing support has the means to pay support. I agree with Mr. Sanford where it's this fine line between those who just, we need some automatic language, that we're not just chasing our tails and doing lots of administrative work when there is no income and it doesn't exist and it's not there, versus this unless language. But to answer your statement, Assemblyman Pickard, I think that last sentence of number 2 is the extent of what's mandated of us versus this commission trying to go a little further knowing that's not quite enough language for us. Ms. Baker?
And I recognize that. I'm sorry. I just, the thing that caught my eye was by operation of law, suspend means the payment due, skipping down, by operation of law is set to 0. If that is truly a mandate to us, then we have no discretion in that matter. But if we have any discretion at all, I would rather see us not necessarily make a finding of imputed income, but allow the minimum support to continue, and then that individual can make the recipient parent whole upon release and reemployment.
But the by operation of law is just California language. That's not the part of the federal mandate.
No, I understand.
Oh,
but,
okay.
My thought was, if in that piece, if that is mandated to us by the federal rule, then we have no ability to deviate from it. But if that's strictly a California rule, then my intent would be to depart from that and let the minimum continue to go. We don't have to impute income. We just allow some arrears that allow the recipient parent to be made whole after the incarceration is over. That would be my personal preference.
Yeah, my testimony would be that that was taken from California. I do not believe in any way, shape, or form that's in any of the federal language. From my memory and my reading of everything, I do not believe it's required at all. The operation of law, it's a direction we went as a committee, but we did not commit to in terms of just borrowing language from California. But that the one part that I know is absolutely required by the federal part is that last sentence of number 2. Which one of you wants to go first? Ms. Baker?
Kathleen Baker for the record. So the Federal Register, for all of you to reference, is page 93527, and it specifically says that the rule doesn't provide special treatment for incarcerated parents. Rather, it requires application of federal review and adjustment requirements, including that orders be reviewed and adjusted upward or downward in all cases upon a showing of any substantial change in circumstances, including a substantial change in circumstances due to unemployment or incarceration, and that incarceration is a substantial change that warrants child support to be reviewed and, if appropriate, adjusted based on the non-custodial parent's ability to pay. So I think that that's the key, and I think what we're trying to determine is, do we want to have a review for every incarceration case, which would probably burden the courts quite a bit, or do we want to have some kind of an automatic adjustment?
Dawn Throne, isn't it part of who's got the burden and providing notice? So, for example, if we had a self-adjusting order to 0 for everybody incarcerated, and then gave notice to the payees that you have a right to contest that they have no income, gives them the burden to come to court, show, no, this is a special case, he really does, she really does have income, and can pay some support. Would that be the best balance of the burdens?
Keith Pickard, I would suggest we actually turn that around and say the burden is on the obligor to show that he is actually unable. Ultimately, again, this is a volitional act that has gotten him into some trouble, and I think his obligation to support his kids, particularly under 125 C002, remains. He may be in a spot where he cannot currently make those payments, but the obligation doesn't go away simply because he's incarcerated. Now, does that mean that he's expected to continue to pay as before? No, and I agree with Ms. Baker's reading as I was reading through that along with her. Then it should be a reason, a substantial change sufficient to come back and discuss it. But at the end of the day, I think if we're going to be consistent with prior statute or statutory declarations that a parent's obligation is to his child, then we should align the rest of the statutory scheme with that.
And this is Joe Sanford for the record, and I don't think I want to have a particular opinion as to whether it should be automatic or not right now, but a lot of the reason to make it automatic instead of a burden on the person who is incarcerated is, I guess, two separate reasons. The first one is that from a 4D perspective and from the federal regs, which is why they're pushing it, is to make it so that the arrears are not so substantial when they get out. And I believe, Mr. Pickard, you expressed that, oh, well, they'd have, like, say, a minimum order for the time they're incarcerated. And sometimes that's the case, but a number of times it's not the case. It'll be, say, they were making $10 an hour or whatever, and they have a $250 child support obligation. That will be the obligation for the time they're in prison until they request, which, I mean, that's on them, and they have the ability to request, at least through the 4D program, pretty much whenever there's a change, so as soon as they get incarcerated. But from our numbers, it can generally look better to not have $15,000, $20,000, $30,000 in arrears, penalties, and interest from a short prison stay, and then when they get out, the generally our research, and I think it's described in the CFR comments, is that there's a very rare payments in that demographic when they're $30,000 in arrears. Generally, it turns into a hiding game where no money gets paid in child support, and they spend a lot of time dodging service, doing contempt actions, things like that, instead of trying to make a payment because they just don't think they'll ever make it. So, in general, as to whether or not we want to have a person who's incarcerated make a request, when in general it's going to end up being a zero order as soon as they make the request, or except in exceptional cases, then I think that's the reason that it's done automatically in California instead of having a system where every time they make a request, we honor it, go and have a court hearing, and everybody already knows that the outcome's going to be zero, except in pretty exceptional cases. And I'm not saying that that's fair to the family, which I don't think there's any objection on my end to the current way we do it now with the $100. I think is very appropriate, but that's not what the Fed is doing and asking us to do.
Keith Pickard for the record. And I appreciate
Hold on,
that,
Keith,
and
I
I
just
recognize.
I'm going to
Yeah,
just
go
interrupt
ahead.
real quick to put on the record that Judge Robb is here and present for the roll.
My apologies, Madam Chair.
Thank you, Madam Chair. I think that your point is well taken, that because of the penalties and interest that are currently in the rules, that arrears number grows very quickly and becomes quickly unmanageable for the obligor. But ultimately, I don't know that the pendulum swinging to the opposite extreme is the answer either. I recognize, too, that part of the intent is to reduce the workload on the 4D program. We all will acknowledge that that's overloaded in terms of the staff that's funded. But at the end of the day, what I'm trying to focus on is what that recipient family should be receiving, but for the individual's voluntary act. You know, I don't purport or don't pretend to think that this would be an incentive to avoid child support, is go get yourself incarcerated. Obviously not. But if you are in that spot, it just, I think the optics are horrible, that a person is now incarcerated and gets the benefit of not having to pay child support. I don't like the look of it. I don't like the policy behind that. I think that a parent, and we fought, and Ms. Surratt will attest to this, we fought hard for the language that we put in 125 COO2 that said a parent has, or parents have, an equivalent duty to support their children. And I think if we were to automatically say, oh, except for when you're incarcerated, I think that sends a bad message, and I don't think it's consistent with the stated policy of the state.
Nova Murray, for the record. The order wouldn't necessarily adjust to zero. In some instances, people have adjusted them to zero, but with the ability to pay, it could go down to the minimum order. If our minimum order is set at 50 or a minimum order is set at 100, they would go to that minimum because obviously they had no ability to pay, so they get the minimum order. So it wouldn't necessarily adjust to zero depending on the policy that we make.
Except that I think with the type of language that was borrowed from California, the goes back to those burdens and whose duty it is to deal with this, because there is that language of unless the person owing support has the means to pay support while incarcerated, but that means the recipient is the one that has to go to court to prove that up under the way we have this with the operation of law. But I do agree it shouldn't go to $0. It should, you know, no matter what, go to the minimum. Worst case scenario, go the minimum or higher depending on what income they do actually have in order to calculate child support. I mean, really, if we wanted the easy way out, not saying we do, you know, all you do is that one sentence about not imputing income, and it takes care of a lot of the federal problems. But it's that full circle thing where I don't think that deals with the problems in the state of Nevada. I don't think it helps the constituency. I think that you were right, Assemblyman Pickard, that we're looking, you know, the feel of it is gross. You go to jail and you suddenly don't have to support your children, but the reality of it is you're in jail, there's no money to tap. And you've also got false expectations that that money is going to come to you somehow miraculously out of thin air when it's not there. It doesn't exist. At least in some cases it doesn't exist. You talk about blue-collar crimes and individuals in prison who still have businesses that are operating and income still to be had. But I think maybe what we're struggling with is that by operation of law, and really that's the key to what we're talking about. It's the automatic part of it, which is an automatic benefit to the individual that's incarcerated and an automatic detriment to the recipient parent who didn't go to jail, versus putting the duty back on the individual who went to prison to get it modified. Go ahead, Mr. Sanford.
Just one other thing to note. I know I got a letter from Child Support Enforcement from the state as it was being pushed down regarding the incarceration of parents and the 4D program's requirement now that for parents who are incarcerated longer than 180 days that we're obligated to look at a review for them anyway. So, I mean, one way or the other, there's going to be a review hearing. So as far as Assemblyman Pickard's comments go, I personally am in complete agreement. I don't like the optics of it, and not even just the optics of it, I just don't like the idea that incarceration is a way to avoid child support at all. But as far as the federal regulations go, and as far as the 4D program is going, I think there's even some question as to whether a minimum order of $100 can be set on a parent with no income and no ability to pay. Whether we call that imputed by the judge or imputed by our statute is, I'm not sure that there's a distinction on that. But I think that's maybe something that maybe other states have already faced. I'm not familiar on the research on that, but I know that the move from the Fed, and this is a fairly new rule as far as the imputation of income for incarcerated parents, is not being done at all, whether they will accept even a minimum order.
Nova Murray, for the record, I'll have staff. It is my understanding that we can set a minimum order, but I have policy staff that can review that. And if it isn't clear in the federal guidelines, we'll talk to OCSE and make sure. But it is my understanding that because you're not using a factor to impute, you used to make $10 an hour, I'm going to give you a $100 order. If the minimum order is set at a minimum order, and that's the way the state function, it is my understanding we can do that, but I will have my policy staff look at it.
Ms. Murray,
Chief
can I
Pickard,
ask
for the
you-
record.
Oh.
No, go ahead.
I was going to ask about that Colorado language. Do you think it's actual statutory language that's beneficial out of Colorado, or is it more of their policies that are behind the scenes within the 4D cases is in terms of collection and enforcement through the prisons?
Nova Murray, for the record, I'm not exactly sure. I've got all of my information secondhand, but what they were looking at was some sort of program where the parent is required to work and working with the prison to get the prison to put a program in place.
Okay.
So outside of this group, sometimes we have the ability to move some of these programs from our perspective. So I'd like to see if it's through their prison, if it's through their state 4D program, and how their regulations are written around it. Because I'm not sure, but I'd love to have an opportunity to see it because they're supposed to have kind of the best practice.
Okay, good to know. Assemblyman Pickard?
Thank you. I don't want to keep spinning our wheels here, but to move it forward, my thought is this, and maybe it helps to suggest first that my understanding is when we were looking at that low-income payor table, we ended up with something not $100, but we ended up with a minimum number, whatever that turns out to be, and this would be applicable. We would be falling within the low-income table. Whatever that minimum number is what it is. We allow that to move forward. We don't set it to zero by operation of law, but we allow the incarcerated person to make the request. Obviously, he's going to have a hard time getting to a hearing, so we probably need to work with language that the 4D program can work with. But ultimately, I think we need to give them the opportunity to have a hearing, particularly as Mr. Sanford suggests, we're going to be having that hearing in 180 days anyway. So, but we allow that to be the point at which he can come in or she can come in and argue that they have no ability to pay, and so it should be set to zero. We actually have that in the current law. But at the end of the day, that's the direction I would like to see, and I may be in the minority here, so if anyone disagrees, speak up, please, but that's the direction I would like to take this.
Nova Murray, for the record, I'm in agreement.
I'm in agreement too, and I think unless there's a disagreement amongst the commission that perhaps the directive out of this, that we're not quite at a place of a motion because we need the actual language in front of us, but perhaps the directive is that I take those points and rework this language for the commission and provide it to all the committee members once again with those thoughts in place and rearranging what we have in front of us. Do we have any disagreement with that? Okay. Then I will make
Nope.
that an agenda item for myself to get this out to the committee again. I did take decent notes in order to do that and modify the language. So just to summarize too, though, before we see if I can re-summarize so that I know what my direction is in redrafting it. We're looking at, as concepts, we're not going down to $0. There may be, it will be just calculated on what it is based on the actual child support calculation, because there's the language regarding if they have the means to pay support. Worst case scenario, it goes down to the minimum, but not zero. That we are steering away from it being by operation of law, instead shifting the burden on the obligor to prove with a required mandatory hearing for review upon incarceration that they are unable to pay. And then keeping the language, the imputation that you cannot impute income language that we borrowed from the federal government. Is that a good summary?
Yeah, we're all nodding our heads here.
Okay. All right, then I have my directive on that language, and we will change agenda items. And now that we have Judge Rob present, let's move to agenda item number 4A regarding our ongoing discussion of the formula to use for child support. Actually, I guess we're kind of, this language was that you provided us, Judge, was a little more on the agenda item about deviations than really the formula.
And it was, the reason for that is, and this is Bridget Robb for the record, the reason for that is this language is where all of the changes were made. And these are all of my notes. All of our, most of our discussion last time really centered around the deviations or the modifications to the formula. And so I attempted to.
So I'm going to just real
Draft.
quick, I'm going to put us into agenda item number 4I so that we're working under a specific agenda item for the meeting purposes, which is discussion and recommendations regarding the deviation criteria, but utilizing the document that Judge Rob provided. Now you can keep going. I cut you off, but I want to keep
No,
us
no,
on
and-
the agenda on appropriate open meeting law
My apologies.
criteria.
My apologies for getting this to everyone late. You don't need to know about why my plate has been full, but it has. You will see the underlined language is what we talked about last time, and there were suggestions with regard to how to modify the language as first proposed. There are also some additions that I built in based on our conversation, most significantly in subparagraph 6, where we're talking about the cost of travel and when that would be a modification factor, for lack of a better term. I tried to go back and using the conversation that we had and also the experience that I have in my caseload, these are the times when modifications are done. The language in the statute, if you will recall, limits the deviation factor to when a custodial parent moves with a child outside the jurisdiction of the court. Well, given the statutory changes, that doesn't make sense anymore, because you can move within the jurisdiction of the court. For example, from Reno to Las Vegas, you're still going to incur a much greater transportation cost than you would when the parties were still in the same city. You're still within the jurisdiction of the court, technically, but there's been a significant change in the transportation status quo. And that's something that I think should be taken into account when child support's being set. So The three places that I've attempted to look at are where one party is responsible for doing all or a majority of the traveling. For example, in many of the cases I have, one party doesn't have a vehicle, and so the other party has to do all of the transportation. The second is where the custodial parent has moved in and has substantially increased the cost. And the third is, in some circumstances, even though it's the non-custodial parent who has moved, they've done so because of a necessity for taking another job, because there's no jobs to be had in the area. And if there isn't some consideration made with regard to child support, that non-custodial parent is not going to be able to see the child. And so I tried to build that in as something that maybe we could look at as well. That's the explanation for the additional language that we hadn't talked about before, and I'll open it up to comment.
Keith Pickard for the record. I don't mean to dominate, but I do have one question with respect to sub 6 here and the reasonable cost of transportation. And that has to do with instances where a custodial parent has fled domestic violence and they've had to travel to their only support group, which is at some distance, thus requiring travel. I think I could probably read into this when we talk about the reasonable cost of transportation, that would give the court some discretion as to find that the cost is unreasonable to the extent that that individual has forced their spouse or co-parent to flee domestic violence. Because what I don't want to do is close the door to the fleeing spouse or parent, I should say. I don't want them to have to pay for the transportation. It's a penalty for that flight, which I think from a policy standpoint is probably a mistake. I think we want to make sure that we've incorporated, and maybe we just put on the record somewhere, or we add some language to suggest that the court has the ability to deny a request for transportation costs in the instance where where one party has been forced to flee domestic violence, and thus the transportation cost should be squarely on the individual who is deemed. And again, we have the language of existing statute where there has been an evidentiary hearing and a showing of actual domestic violence occurring, that then that individual would be shouldered with the transportation costs. I don't know how to draft that, but that's just my comment.
I can certainly take a stab at it. It was not that wasn't a circumstance that I had contemplated, but it's a legitimate one, and I agree with you. I don't believe that it is covered in the language that is currently here, so I can take another stab at this.
Kimberly Surratt for the record. There's plenty of locations in our statutes where we've made domestic violence exceptions, where I think language can be borrowed easily, because just about every time we're at the legislature on any of these issues, that's part of what we have to contemplate every time as an exception. So I think we've got plenty of places to borrow from. Judge Hoskin, did I just see you reaching for your button?
You're not supposed to watch me that closely. Yeah, I was just going to comment that it's not mandatory. The language that Judge Robbins suggested says may, so the court can take those into considerations. I know we've had discussions where perhaps we want to give more guidance to the court rather than less, and this may be one of those. But certainly the ability to consider what Assemblyman Pickard has suggested exists in the draft. And as I read through it, and I didn't get to see it till just a few minutes ago, but I'm pleased with the language, and I appreciate my esteemed colleague up in Reno for putting it together.
And this is Joe Sanford for the record, and I like the language. I'm looking again at subsection 6, and in particular I'm looking at possibly changing the language slightly to have sections 1 and 2 be required, with section 3 being an or, just because the way I read it now, it could just fall under section 1. One parent is required to bear the majority of the travel expenses, say they move across country. So it wouldn't have required either a custodial move or best interest. Just the fact that the one parent has the majority of the expenses would potentially be a reason to deviate, and not that the judge would necessarily grant that, but I know a lot of enterprising attorneys that would at least make that argument. So when I read it, I look at as 1 and 2 together are important, and number 3 gives the judge the ability to take the best interests of the child into account, even without requiring the specific situation of a custodial parent move.
Nova Murray for the record. I agree.
Judge Hoskin, couldn't we solve that problem with, rather than just having or, have and/or?
I'm not quite
I
sure
can
what.
see one, I can see just one being sufficient, and I can see more than one being part of the decision being made by the court. So I don't know if that satisfies Mr. Sanford's concern if we go to and/or rather than just the or.
This is Kim Surratt. I think, yeah, the main purpose of number 1 is really if one parent is required, meaning the judge found some other reason in court. I mean, that's that big discretion of the court that they decided transportation costs had to be paid by one person versus the other. That may even be the domestic violence exception, quite honestly. That's part of that analysis. I looked at number 1 as being when domestic violence might be one of the reasons why they were required to bear the majority of the travel expenses. But
But in that case, you wouldn't want to modify down.
no, well, you would want the judge to just designate who's responsible for transportation, and depending on who's the payor versus payee, then it adjusts depending on.
And I apologize, I was looking at this myopically because it isn't just a modification down. You can modify up. As well. Yeah. And I think, Congressman Pickard, that requiring one party to bear the majority of the travel expenses, for example, in the circumstance where there's domestic violence, would be a potential deviation up, as opposed to simply one down.
Yeah, I mean, that's always the key with deviations, right? That it can go up or down.
Right.
And this is written still appropriately for
Chair?
that. So, yes.
It under F, the first is, it refers to it as an adjustment, not up or down. So I think that we already have room for that. But I guess from a drafting standpoint, I have, I understand what Judge Hoskin is doing. I don't think we need to go and or, because then, of course, and or almost offsets each other. But I can foresee instances where sub 1 would apply and be enough to justify an adjustment, and number 2 to be enough. So if we were to use and after sub 1, my concern is we've just significantly narrowed the court's discretion, because now you need both of these in order
Right.
to make the adjustment, when there are going to be instances where just one should be enough. And since it's or, then although I have a problem with or, it's in the best interest of the child, because obviously 1 and 2 also have to be in the best interest of the child. I would suggest we take that out and make that part of the paragraph, the sentence above, the reasonable cost of transportation, and it is in the best interest of the child. Because all of these should be guided by that best interest analysis. And then 1, 2, 3, and then maybe 4, the exception for the domestic violence. And I would suggest because we have made that deviate or that exception so bold in the past, we should continue to do so here.
And Nova Murray, for the record, I've had recent complaints of situations where the non-custodial parent leaves our location long distances and in court battles is winning a deviation down to see his children that he chose to move away from. So this does give that entity the ability to get an adjustment down because he chose to leave his children. So I'd like to add that idea that it's in the best interest of the child and the judge makes that determination instead of leaving it hanging by itself.
And with due respect, I disagree a bit with, of course, the entire idea of anything involving children is the best interest of the child. But when we're talking about child support, we're really talking about the finances between the parents. And the one parent who is bearing or has the responsibility to bear the majority of the travel expenses, that really isn't a best interest analysis for me. Whether the custodial parent has moved with the child and there's a substantial change in transportation costs, again, I don't see that being a best interest standard. I see that being an allocation of the cost of travel. I specifically wanted to use best interest to give us on the bench the ability to take a look at a circumstance and say, we are going to deviate in the amount of child support because even though there is little child support here, or even though the non-custodial parent moved away, if there is a circumstance where the best interest of the child would require some kind of modification so that visitation can happen, that's why I included best interest there. It was really a discrete reason. And Ms. Murray, in my experience, the majority of the time parents move away, it isn't simply to leave their children. It is because there are other, usually economic factors that are compelling that move. And if someone is unemployed where they are with their children and move so that they can support their children, I have a hard time saying you don't get a break with your transportation because you moved away from the kids so you could get a job. That's the circumstance that I'm trying to address with sub 3.
And Judge Robb, I want first to echo the sentiment of Judge Hoskin. At first glance, I'm just thinking out loud. I like the language. I could live with it as is, frankly. I could make the argument that all of my concerns already have been addressed. So first, I was just thinking out loud, but having heard that explanation, I agree, frankly. I'm happy with the language.
Nova Murray, for the record. So I'd say that my opinion comes from serving a different population. I don't serve the bulk of the state. I serve the impoverished. And so taking money from somebody who already doesn't have enough money is where my concern comes from. If she's only going to get a small amount and he reduces that even greater because he chose to move away, I don't know. I guess in my mind, in my front page test, I stay as close to my kids as I can, even now as adults, to be involved in their lives, and maybe I would have to take a different job or learn a new trade to do that. So I really come from a different side in the impoverished world versus the big picture.
For the sake of this committee, everything's gender we may use one gender for the public, but it's both genders on both sides. Just gotta throw that out there. Yeah, I think I agree with Assemblyman Pickard that with the language on its face, I'm happy. I do get worried when we start putting best interests of the child into the child support provisions. Because we really do keep those standards separate. We have a math calculation over here, and we have best interest of the child over here. Sure, everything we're doing is about the best interest of the child, but we really do keep them as two separate principles. I still think that even in that scenario, if you look at number 1, where it's the reasonable cost of transportation associated with visitation if one parent is required to bear the majority of the travel expenses, we're talking about deviation factors. So maybe, in order to do best interest or to deal with the scenario like you're talking about, it may be one parent is required to bear the majority or minority of the travel expenses. It's just whenever there's a shift in the travel expenses, that can be a deviation, no matter what the shift was or what the reason was. And that allows for all those reasons that are the person who needed to take a job out of town because they could not become employed in town. The domestic violence scenario, it covers that. If it's not just when one person's required to do majority, it's any shift in the travel expenses. But under that argument, you could get rid of number 2, and and now you're just down to number 1, right?
I understand and I respect very much the idea of less is more. The problem is sometimes you need a little guidance to help guide discretion. And I was trying to give that little guidance without handcuffing people or giving too much.
Keith Pickard for the record. I agree completely. I think guidance, and this comes from my experience working with judges after AB 263 in the 2015 session. The one consistent comment I got was, you didn't give us enough guidance. And so I agree we should probably maintain all 3, and I would like, and this is a personal thought, I would like to add 4 being consideration of instances of domestic violence, because I do think that's been an important exception in other parts of the statute. I think it's a good practice and good policy to maintain that. But as I say, I could live with it as is, but personally I would like to see that added to it.
I'm in complete agreement with adding that 4.
I'd agree too. This is Kim Surratt.
Judge Hoskin, just weighing in on that one. In the effort to give more guidance rather than less, I would suggest that when we're talking about DV, the DV directly relating to the relocation rather than just DV in general, which was probably understood, but I didn't hear it yet.
Yeah, I would second that. That's Keith Pickard for the record.
This is Joe Sanford. Just in the interest of giving more judicial latitude, or less, I guess, as it is there any interest in moving Section 3 minus the will permit visitation to occur to, say, a Part 9, and just saying, a DV, this is an adjustment could be made for any need that's in the best interests of the children. I think that some of the deviation language we looked at from other states has sort of a catch-all provision like that already, and that would sort of be that provision.
The only hesitancy, and this is Bridget Robb for the record, the only hesitancy I have with that kind of catch-all is our direction from the Supreme Court and quite frankly from the federal government has been deviations are the exception, not the rule. And when you put in that kind of catch-all, that becomes the exception that swallows the rule. I am leery of doing that.
Kim Surratt for the record. I think that's also the reason under number 1 and number 6 with this redraft that we included the word reasonable to give ourselves some flexibility and give the court some flexibility on making that determination about what is reasonable.
And just for thought, it doesn't have to come in this particular section of the proposed language, But I think somewhere in the proposed language, we should say that the percentages are, as the former statute said, presumed to meet the needs of children. And since we know what the percentages are supposed to cover, what is subsumed in those percentages, and unfortunately, I wasn't clear enough to be able to put that into the language, whether it's some component of childcare is included, what exactly is included in child support. I think maybe we include that language saying this is what the percentages are to cover, and that's already been calculated in. If there's something over and above that, something extraordinary, that's when these modification factors come in.
Further comment?
Keith Pickard. I agree with that. I think that because of the way number 1 is written, which has not been included in the child support established above, I think then that mandates essentially that we dictate, we line out what is included in that. And I noticed that, Madam Chair, I'm glad you're coming back. This is now raised the specter of percentages and whatnot. I don't know if you want to get into the discussion.
I want to get into that
had before the
discussion under a
meeting.
different agenda item when we have the language right here
Okay.
in this dealt with, yeah. I just wanted to get a
All right.
Connex fix.
No problem. So I guess to move this forward then, I would just ask that we go ahead and move along the line that we just seem to all agree to, that Judge Robb will take another crack at this by adding a fourth sub to sub 6, and then I think we'll be in a spot where we can actually move forward. Also, Madam Chair, for the record, Senator Roberson has just arrived.
Hello, Senator Roberson. Good to see you, sir. Almost see you.
Hello, I've been here the entire time.
Oh,
I just
you're
thought we were in
hiding
other
on the
room,
end.
so after an hour, it dawned on me to walk over here.
All right, I would agree, and I think with that, we don't need any formal action taken on that in terms of just it's a further direction that Judge Robb will make the modification for the DV exception and represent that language to us again, and we'll have this as an agenda item once again. And with that, I would propose that we move to agenda item number 4A, which is the general discussion and recommendations as to what formula to use for child support after elimination of the presumptive maximum amounts. And Assemblyman Pickard, I think this is the appropriate time and agenda item for us to have a discussion of what is going on with the Child Support Commission. For the record and for the public who are listening, there has been a formulation of a child support committee. It's not really a commission, but a committee through the Supreme Court to study legislative changes to child custody statutes in the state of Nevada. That committee will study the current status of our child custody laws and make recommendations for legislative change out of that. It is not structured like this commission. It is not legislative. It did not come out of the legislature. Rather, it is a study group, essentially, to create proposed legislation that will be hopefully pursued out of that committee at the next legislative session. It's got members of the Family Law Executive Council who are watching also for lobbying purposes to see what the recommendations are out of that committee. The guidance and, we don't know what direction they're going to go, Assemblyman Pickard, but part of the concern is, or not concern, but one of the highlight comments for this committee is that one of the potential directions they're going to go is to eliminate the labels of primary physical custody, sole legal custody, sole or joint legal, just the labels of legal and physical custody and steer away from that. How they're going to accomplish that, what direction they take, if that ultimately is the decision they make, we do not know. I know, Assemblyman Pickard, your concern was that we bring that up and have a discussion in this committee in making our decisions about changes to the child support statutes. Before I open it up for discussion, I'll make one other comment on that, which is this commission is an ongoing commission. We will not, for lack of a better word, die at the end of our report in July. It's an ongoing commission that will have ongoing ability to make recommendations for changes. So even if we make changes this year that become obsolete as a result of custody changes in the next legislative session, we will still have an ability to make modifications. But aside from that, obviously, if that's the direction they're going to go, it would be nice to not have to rehaul everything we do over again just based on the next legislative session. So if we have any foresight on that, it probably wouldn't hurt us to have the discussion about that. This committee's had discussions about getting away from those labels. We've had public comment about getting away from those labels. I think it's important that we look at ways to get away from those labels. And some of that discussion brings us back full circle to discussions we're trying to stay away from, which was moving in an income share model direction versus working within what we currently have without utilizing labels. But Assemblyman Pickard, do you have additional thoughts and comments you wanted to make on that?
Well, I appreciate that. And I think you've summarized it fairly well. I think that this is something that we should address. I know it came up in Mr. Schoen's presentation in the last meeting that, the income shares model is a decision we've already theoretically made. Well, not theoretically. We actually made a motion to stick with the percentage of income model. And so because of what, so everyone knows, and it's on the record, I had, before the announcement of the Child Custody Committee or Commission, I had started putting together an ad hoc committee of my own, an advisory committee, because one of the things that I wanted to look at was this very issue, whether or not we can successfully get away from the labels. What would it take to do that? What are the consequences and some of the perceived unintended consequences that would arise and that sort of thing. When that was announced, I had already talked to actually some of the people who are now on that committee. And we'd already had some substantive conversations about getting away from the labels and why that would be. One of the comments that I've heard recently was, how does that then, how do we avoid the non-custodial parent receiving child support from the custodial parent? So those would be the types of things that we would want to address. But ultimately, if we were to consider an income shares model at this point, it would require us to go, step back, undo the formal decision we've made, and then determine whether or not we want to go full steam ahead down that direction instead, or do both models, or at least discuss the things that we're going to do in terms of both models. And then when the Child Support Commission the Custody Commission actually comes up with their recommendations, then that will help us decide which direction to go. I'm not suggesting any of those three options per se. As I'm getting that feedback from the people that are actually going to be doing that analysis, it seems to be most of them are leaning, or those that I have spoken to are leaning towards going to a non-label timeshare. So it's strictly a mom gets X amount of time, dad gets X amount of time, and then we would arguably need to adjust the child support guidelines to match that. But as you say, that's going to be a legislative response, so nothing's going to be changing until 2019. So maybe it would be best if we just move forward with what we have, maybe incorporate some exit paths or draft what we're going to draft with the idea in mind that this might change. And so we do it in component parts so we can unplug the percentage of income component and plug in a percentage, or I'm sorry, the income shares model, so that we don't have to rewrite everything we write. So those are my comments. I just wanted to get that in the heads of those of us that have to deal with this, because I suspect that's the direction we're going to end up going.
Additional thoughts, comments?
Nova Marie for the record. We are rebuilding the 4D system right now, and with this information in mind, we will be looking at trying to build it both ways.
Awesome.
Well, that's good to know, because I know
That's good to know.
that,
I think that's my biggest
one of
fear
the,
is we do these things, we cause $1 million budget problems.
Right.
Every time we change something. Okay.
exactly, and since we are at a spot in that development where we can actually plan for it, I think that's a very wise move. Thank you.
The other, to add a little more input too, I think it's something that, there was critique about having David Schoen give his presentation last time when we had made a decision to not do income share, but I think we have to keep in mind that whether it's called income share or it's not an actual real income share model, that desire, that public comment is ongoing, from the lawyers to the public to other interested parties, that the labels are detrimental. And I don't want us to lose sight of that just because we decided to not use an income share model. When we have other creative models given to us, they may ultimately be an income share model, but that doesn't mean there isn't stuff we can borrow or learn from those ideas so that we can meet that public need. Because, in my opinion, we've heard plenty from the public that is a desire and that is a need that exists. Okay, so that I brought up under agenda item number 4A, mainly because it colors our discussion about the calculations. Did anybody have an opportunity to take a good look at what was proposed last time for 125B 070 by Judge Robb? Other than all the changes we just had on the last section, on section F, about the deviations, but just looking, because now we've had time to actually swallow it, really take a look at it. There were some comments last time from committee members that they hadn't had time to do some math calculations under it. Has anybody done that and have additional comment they would like to give or changes they would like to make? I'll throw one out there. I know we had some discussion last time about adding somewhere a definition of what the child support is for. And so we still have that language we need to craft, and that discussion also came up just now when we were doing the deviation factors about being very clear about the definition of what support is for and what it isn't, what it covers and what it doesn't cover. And then we discussed also, but I'm going to make an assumption, we discussed receiving some child care data and information, but you didn't have enough time for that, huh, Ms. Murray? Huh. That was a very technical word, huh?
Nova Marie for the record. I actually have the data. It's in something that isn't protected, and it's big. It's all the data from the state. It's all the entities that participated. So I'm looking at how to protect it when I send it to you so that things aren't inadvertently changed. But I do have it all, and I can make it available.
Or some summary? Because I know that was kind of one of the key points for me on the childcare part of it, because in our deviation factors, we've removed, well, no, I shouldn't say we removed, but we did keep the one factor at the top regarding reasonable cost of childcare, but then we all talked about, to use Judge Hoskin, your term, baking it into the child support amount as a possibility, depending on what those numbers are, what the results were about childcare costs in the state of Nevada, to see where we're at in terms of when we do these math calculations, how they come out in comparison to the actual average cost of raising a child in Nevada and the actual average cost of childcare in Nevada. Any other comments about the additional language now that everybody's had an opportunity to read it? Okay.
This is Dawn Throne. I think where we were last time was talking about a 3-component calculation. A, do the percentage of income. B, add the health care costs and how we were going to divide that proportionally or equally between the parents. And C was the child care, because that is a huge component. I think that's where we left off. And then accepting the low income and the high income from the general percentage. But we have to go back to a bigger problem of the percentage of income assumes that we know exactly who the custodial parent is, who is not the custodial parent, so we know who the obligor and who the recipient is. If we're going to change and do away with these labels, how is the court going to know which of the parents is supposed to be the payor and which is supposed to be the recipient? Based on income? Based on timeshare? Based on a combination of both? Which?
This is Bridget Robb for the record. What I think we do when we change from the labels that we use now is we are simply going to be kicking the fight to new labels. Income share, that's going to drive its own litigation. And when we're talking about timeshare, we are going to, I think, get to a place that I have feared for a long time, which is counting the number of hours in a day that a child is with either parent. And that's something I've resisted for as long as I've been in this position, and is something I think that if we go away from the labels, we are simply driving the fight to different labels. It's the same fight, we're just calling it something different. I don't think it's going to alleviate the problem at all.
Keith Pickard for the record. If we were to do this essentially on an always Wright v. Osborne analysis, where we're looking at the income of both parties and they're essentially taking a proportionate share, I think, well, let me back up half a step. The argument that I've been hearing for elimination of the labels is because you end up with this incentive to get joint physical custody at all costs, so it reduces the obligor's child support number. If we do away with it and we do it on a proportionate share of the total, then it's however much time the parents actually have with the kids. You're right, I do think that we're going to maintain the litigation over the parenting time, but I think that by itself is probably enough to fight over. We're removing then this perverse incentive to argue for joint simply because the child support amount is going to be drastically affected if we don't. But I agree, there's always going to be something to fight over. I think that the discussion was trying to do, the discussion around the labels, was eliminate the perverse incentives and let's fight on the merits of it. But I agree, if we make a wholesale change, then we have some really good creative attorneys that are going to come up with arguments that we're going to have to deal with. My point, though, was strictly looking at this from the perspective of if the labels change, what kind of guidance can we insert in this to give the bench the ability to make that very determination? How are we now going to calculate child support? So your point is well taken. I just think that if we do believe that the child custody committee is going to go in that direction, that we be prepared for it.
And this is Joe Sanford for the record. I guess some of the concern with the labels right now is based off the case law that exists, the granularity between primary physical custody and joint physical custody really is, it's either or, well, not quite either or. You have below 40%, between 40 and 50%, and 50%. And so there is a lot of incentive to have a designation between 40 and 50% custody, or if you're the custodial parent, 40 and 60. So I'm wondering if in our formulation of a child support guideline, if we were to, in a way, take away from it being a case law determination, but add more granularity between, say, 20%, 30%, 30%, 40%, 40%, 50%, those labels aren't what's important. It's shifting that fight to be, where you're going to be, but making the distinction between being in the 25 to 30% level versus however fine we want to create that. Obviously, we don't want to be counting every day, so I think we do want to have kind of broader tiers than just 2 or 3 or 4 days, but say 10, 15, 20 days where we're not fighting each day, but a couple of week periods of time to say, okay, are you in section 1 where you're between 20 and 30% of the time? Are you in section 2 between 30 and 40% of the time? Are you in section 3, what is currently joint physical, between 40 and 50, or if you're the custodial parent, 50 and 60%? So whatever labels we end up calling that, I think the fight right now, when I perceive it, is because there's such a huge cliff, I guess, right at the 40% mark. There is a very big incentive to get over that hump if you're going to have visitation at all. Otherwise, you might as well, from a money perspective, really just not have any time. And I think that that's kind of the perverse situation it's in now. And so when we're drafting this, regardless of what the Child Custody Commission ends up deciding the labels should be, or changes the labels, or wants to do it on a count the number of days. Honestly, if they're going to count the number of days, that might make it easier for us, because the orders that come out would have days counted, and it would make it easier on the child support calculation to find out exactly what bracket you're in. But that if we were to maybe make whether we want to call it a deviation factor or what, similar to health insurance, to sort of codify the Wright versus Osborne, Rivero stuff, but add, I guess, more layers, might resolve that fight.
Judge Hoskin, for the record, just to kind of throw what, at least from my perception, a reality check on this discussion. First of all, let me indicate that I don't see 40% as a cliff. I think the Supreme Court has given us more discretion than that, and I can make a joint physical finding on 30 or 20% if I can make sufficient findings. So I don't see that as drastic as it was portrayed. The other side of it is my concern in getting too specific with it is the fact that somebody's going to come in and get an order that their child support is based on the number of days a month that they're visiting with the child, and then 2 months later I find out that they're not visiting with the child at. So we're incentivizing additional litigation is my fear if we're too specific with let's play the percentage game. Realities are a lot of times different than the orders we put in place, and there's some comfort level in an obligor and an obligee based upon broader spectrums of visitation rather than more narrower areas of visitation that make your orders a little more concrete and a little more long-lasting based upon that. So while it may be possible that the other committee suggests that we do away with labels, I think that from our standpoint, we're tasked with putting a child support obligation together rather than diminishing that obligation based upon what may or may not happen in the future. So at least from a judicial standpoint, I'm a little comforted in the fact that I can put an obligation together that really isn't affected too much by exactly the visitation schedule that the parties decide to follow after they walk out of the courtroom.
This is Judge Robb. I agree wholeheartedly with what Judge Hoskin just said. And if I'm being cynical, and sometimes I'm required to be, the money is always going to drive what a parent asks for, no matter it. I've said this before, it doesn't matter what the label is. You either look for joint physical custody within that 40 to 60% spectrum, or you are going to drive this is the parenting percentage, parenting time percentage that I have. If we have people with bad motives, they are going to use those bad motives no matter what we call this thing. And so I hesitate to throw this out, the structure that we have right now that we voted on a supposition with regard to what another committee is going to be doing in the future. We've got a structure. I think maybe we live within that structure, including the labels, with the understanding we may need to come back to the drawing board and be flexible and creative down the line if the Supreme Court committee tells us something different. But right now, we know what those labels are. I think that's what we need to live within.
Keith Pickard for the record. And Judge Robb, I'm persuaded by your comments. Let me ask, though, if as a judge, if we go down this path, we maintain what we've been doing, and I think that will make it easier for us if we do, and we base this on the structure we currently have, and then the legislature, and I agree that it's probably not the wisest thing, as just Hoskin was alluding to speculate as to what that committee may or may not do. But as a judge, I'm wondering, would it be better for us to have some language that would give guidance to the court should that change be made, or leave it as is and then because maybe I just misperceive it, but I perceive that we would have now an inconsistent child support guideline that there would be no guidance for. That now we're basing our child support on labels in 2019, assume for the moment that the bill that the Supreme Court would bring passes and we've eliminated those labels. Is it worse for us as practitioners and judges to not have that guidance built in because we would be reacting to it? What's your thought on that?
Assemblyman, I would answer that in a way that I answer requests sometimes that are made in court. You've asked me for an advisory opinion, and honestly, that's not something I can give you. All I can do is work with the structure and the facts that we have, and it concerns me that I think if the legislature wants to change these labels, the legislature is then going to have to give us the remedy that those label changes are going to require. I think that's got to be part of any legislation that is put forth. I'm afraid that putting something in here that wouldn't be used and is simply an assumption that something may occur in the future would be both a nullity and confusing until the time that that eventuality actually occurs.
Keith Pickard for the record, and I appreciate that. And I was, I'll respond the same way I do when Judge Oskin tells me I'm asking for an advisory opinion. And that is, I wasn't asking for the opinion, I was just asking whether or not you felt that that was danger enough to respond to it. But your point is well taken, and again, I'm thinking out loud more than trying to advocate for a particular direction. It's a concern of mine because it's already been on my radar screen. But with respect to the legislature, if they do in 2019 go away from the labels, I would be working very hard not to address child support at all in the statute, because that's what we're getting away from right now. One of the things that we dealt with in AB 263 was the accretion as to how the custody laws had changed over time in the various sections. We don't want to go down that road again. I don't want to address child support in statute at all. I want it completely within the regs so that this committee then every 4 years or so or less can address the issue. So that was the sum total of my concern. We've discussed it. I don't know. I think I'm satisfied. But anyway, that was it.
Okay, so I'm going to move us into a direction that we had earlier in this, which was for this language, for this section, we had agreed on adding a definition of what support is for, kind of to front end this. And in order to lighten the drafting obligations that we keep putting on Judge Rob, does anybody else want to volunteer to create that language to propose for the next meeting? Come on. Somebody's got to volunteer. Someone other than Judge Rob has to do some drafting. And me, I'm doing the incarceration language, so somebody else pipe up.
If Judge Rob will send me what she has, I'm happy to give it a shot.
Thank you, Your Honor.
And Madam Chair, if you can send me your notes, because I'm sure you're taking better notes than I am.
My whole note is at the very beginning of her language, add definition of what support is for.
All right.
But the discussion we had around it, excuse my nose, it's horrible. Discussion we had, which is when the court gets to the deviation factors, it's helpful and beneficial that we know what it is that our child support contains versus what it does not contain, what it is meant for. And some of that came off of that USDA language from the last meeting. And Mr. Sanford actually was the one to point out some of that language within the statute. And I think if we look at the notes from the last meeting, we can find where, I think it was page 27. I have a recollection of it being page 27 because I was so awed by you finding that language. Am I right? Yes. It was page 27. Aha. So look at page 27 in the guideline review.
And 25.
And page 25. And I would say that dependent on the next meeting and receiving some more information on the child care costs in Nevada, I still put out there that we may still be entertaining moving that, the child care as a deviation factor and moving it to how we have the medical costs as a formula, but we wanted to see average costs of childcare and compare that to the baseline of average costs of raising a child in Nevada and the bake-in theory of whether or not childcare is baked in or not. Okay, so Have we killed that topic for right now with those changes? I think we have. Let's move on to I'm trying to figure out what's the best place for us to go right now. All right, who wants to volunteer on what topic they want to talk about next? We can just go in order on the agenda, or we can pop in with what we think we're actually prepared to speak on right now.
Madam Chair,
Yes, ma'am.
we had talked briefly, going back to the proposed language. There is a policy decision to be made with regard to subsection C, and it is whether medical costs and the costs of the insurance premium are to be borne 50-50 by parents, or whether there's to be a percentage share. I can argue either side, and so I'm interested in it. We can deal with the drafting and firm up this language as well if I have some guidance as to what the policy preference of this group is.
Okay, so I would put that as we will have that discussion under agenda item 4G, discussion and recommendations as to how to develop and adopt an adjustment for child's health care expenses. And we'll open the discussion on health care expenses. You're right, I have the same recollection that we did have some discussion about staying at the 50-50 or based on percentage of income share, separate, just within that bubble of the healthcare costs. Any thoughts or comments on that?
This is Judge Robb. The only comment I have with regard to the 50-50, and one of the reasons that I like it is, and it may just be a psychological peg, but it makes both parents understand that they are both responsible for the child, and that they also both then, because of that responsibility, are entitled on a legal custody side to be informed and to be engaged in their children's health care. There's something with the 50-50 that I like, unless there are extraordinary reasons to move away from it.
This is Kim Surratt. I think I feel that within my practice that we have fewer problems or complaints about the medical costs because it is so clearly written out in the statutes. Because that 50% is there, that's how it's dealt with, that's what they've got to do. They're on autopilot with it. We, of course, still have plenty of problems with one or the other not paying their 50% and having collection issues. That's an ongoing problem, but we don't seem to have people, when they know the statute says they each have to pay 50% of the medical. I feel like my clientele, at least we see, are fine with that. Doesn't seem to faze them.
Judge Robb again, and the comment that I hear almost uniformly is, this is my child, of course I'm going to pay 50%. I mean, it's a given, and they understand that. It was raised, though, and I just want to make sure that I understand what the temperament of the group is.
Kathleen
Keith
Baker for the record. Go ahead, Assemblyman.
Go ahead, Kathy.
So I was just thinking, there are actually two distinct issues here. One is the payment of out-of-pocket medical expenses, and the other is the payment of the insurance premium. And at least in the 4D world, we deal a lot with who's providing the health insurance premium and how that premium is being paid for, which is separate and aside from the actual medical expenses, which are not as determined. And I think, whether... Well, we do have them come back and reduce them to judgment, but still there is the premium. Sometimes we have them on Medicaid, there's no premium. Sometimes the premium is, covered under a union. Sometimes the premium's very low, sometimes it's very high. And I think that the question is, do we stay 50-50 with the health insurance premium, which would then be, as I think we're talking about, baked into the formula.
Keith Pickard, thank you. Madam Chair, in my regular practice, I agree. I get very rarely get anyone complaining about the 50-50, but I do get it fairly frequently in the pro bono work that I do, where I'm working with someone who can barely scrape by, and now they've got to shoulder half of the medical expenses when their former partner or spouse is making enough money they could easily pay for both halves, that is. So, but I agree, it keeps it simple, it's very easily understood. What I would suggest is to add some language to allow the court some deviation, because right now it's not in a rule. Yeah, Judge Hoskins pointing out that unless in extraordinary circumstances, so actually it's there and I just forgot. So anyway, with this language, I will concede the point and be quiet.
And this is Joe Sanford again. Looks like the whole group sort of seems to be on point, but just from the 4D perspective, I would like to again reiterate, I'm glad that we're moving with generally the 50% unless in extraordinary circumstances, just because, again, we may not have the income from both parties. Typically, we'll have the income from the obligor, who will be providing the medical insurance. He'll generally would have, or whoever would have, through their employer, whatever the amount that we are setting. And so it's really a deviation piece, generally down. Not in all cases, but generally that's the case. And so it alleviates those cases where we would not have income from both parties to be able to do an income shares type version.
Assemblyman Pickard, within the language that Judge Robb has proposed under Section C at the very end, it says, unless in extraordinary circumstances the court determines a basis exists to deviate from this percentage. Is that sufficient language for what you were looking for when you just said allow the court some deviation discretion?
Yes, Madam Chair. I don't know that I would use the term extraordinary circumstances. That seems to set the bar pretty high, but that's a semantic issue, and that's not a hill I will die on. But yes, I think that addresses, it gives the court the discretion to find extraordinary circumstances and deviate from the 50%, and I think that's appropriate.
Well, except it becomes a definition issue of, are we clear as a legal standard what extraordinary circumstances are for deviation of that, or do we want the court to have a little more discretion than just extraordinary circumstances?
Well, again, Keith Pickard, for the record, my experience after 2015 session was that definitions are greatly appreciated by the bench. And so if we're going to put that in, if it already exists in statute somewhere and is appropriate, then we can certainly cite to that. But if it isn't defined clearly or in a way that fits this, I think we should add a definition so that the bench is guided as to what constitutes an extraordinary circumstance.
Wouldn't we want it to kind of mimic the language in the deviation factors at the beginning where it just says it may be adjusted by the court to meet the needs and needs of the child and the economic circumstances of the parents, versus say that the court has to find extraordinary circumstances to modify it from the 50%?
This is Judge Hoskin
Yeah.
weighing in. Now I'm trying to come back with the thought I just had. We can do away with extraordinary and just indicate that if the court's going to do anything other than 50-50, that it'll make specific findings as to the basis. And then that way nobody's able to just run roughshod over the rule. There has to be specific findings, but you still have the discretion for those circumstances, like the examples that have been raised.
Kim Surratt, I agree with that requirement. And of course, we have some of that specific findings requirements in other language that I believe is outside of the statutes that's within our scope necessarily. I don't know, I think that language, the language regarding specific findings is in another statute, is what I'm trying to say. But it doesn't mean we can't incorporate it in here in these specific spots where we're giving the court the discretion for deviation.
Nova Marie, for the record, do we need anything specific in there speaking to public coverage? Is it understood? Does it need a definition? I'm just not clear on what.
Talking about public medical,
So Medicaid,
Medicare,
Medicaid and CHIP are acceptable coverage. And I don't know if that needs to be stated or needs a definition of what health insurance coverage is, because it is now acceptable to use that piece of it.
Well, the very next part, subsection 1 under C, does talk about definition of medical support and what it includes. And then I thought our prior language on that had talked about public assistance. I think it's a different section of statutes. Doesn't mean it can't be repeated right here, but I feel we have that somewhere.
We do. It wasn't in this portion of the statute. It is.
Right.
It is there. The medical support language that I used was from the statute that we had, and I just, instead of having it be a standalone statute, added it in because we wanted to be able to, instead of using it as a deviation, include it just as part of the formula.
Somebody want to take on the duty of kind of doing a little bit of research on that for next time to make sure that we've incorporated all the proper medical language from other statutes into this section? I'm thinking, Dawn, do you want to do that?
Yes, I can do that.
Okay.
Dawn, this is Bridget Robb. I believe that those statutes are fairly close in proximity even to the language that we've been working off, so it shouldn't be a huge problem to do the research.
I think cross-referencing those will be good for us, though, to make sure. And to incorporate the concern that Ms. Murray had about public assistance on the medical being part of that definition. Because I believe it exists somewhere. I just don't know where it exists, because I know. And that was a change that was recently made in the past maybe 5 years or so, I feel like, that to include that definition as being reasonable medical. Yes.
Keith Pickard for the record. Do I remember correctly that there's a mandate that if private insurance is available, that Medicaid, that should be ordered and that Medicaid should only be a fallback, or is that from another jurisdiction?
Assemblyman Pickard, your recollection is correct, and that's part of what this language is. You are required to obtain private insurance if you can obtain it at a reasonable cost. A reasonable cost is 5% or less of the parent's gross monthly income for the premium amount, or if adding a child to the premium would cause no greater amount of the premium than, again, a 5% of the parent's gross monthly income. The only question I have ever had is if we're having the parents split the cost of the premium, is it 5% of each parent's gross monthly income, or is it 5% of just the parent supplying the insurance gross monthly income? Judge Hoskin, have you thought about that at all?
No, I try not to think about it unless I'm forced to think about it. But I think it's a good catch. I think we're going to run into that question if we don't specifically define it. But I think a lot of this falls back on what are those numbers? What are those estimated costs? What are we baking in or what are we not baking in? And is 5% of both parents appropriate, or is it 5% of the one that's paying it? I think it's something we probably need to resolve before we're done with this.
Nova Murray for the record. I think Don's research will take us to some of that. I have the policy aspect. In the new federal law, I believe that things change for us, and you'll no longer be required to do the private insurance over the public insurance, because if mom's required to pay, mom or dad, if the custodial parent's required to pay half of it, and we've already determined that she's impoverished, she could have those children on a program that's free. I believe that's what this federal regulation changes, and I believe Dawn will find that when she looks at what we're missing. And if you need any help, Dawn, I can have my policy people work with you.
Thank you.
This is Joe Sanford. I don't do a lot of the payments of cash cases through the 4D program. I know a lot of the welfare cases do, but I'm looking at 1C capital A, payments of cash for medical support or the cost of coverage for healthcare are reasonable. And I'm just looking at the payments of cash, and it looks like that should be possibly defined above in section 1, where it's as used in this section, medical support includes without limitation coverage for health care, but payments of cash isn't used up there, or accepted as medical support. Should we include, as used in this section, medical support includes without limitation payments of cash and coverage for health care under a plan of insurance that is reasonable in cost and accessible? Because I know that we do have cases right now where we do cash payment instead of some type of insurance.
All right, Mr. Sanford, I think we're all reading right now, based on what you just said. As used in this section, medical support includes, without limitation, and you're proposing payments of cash and would be and/or coverage for health care under a plan of insurance that is reasonable in cost and accessible, including without limitation the payment of any premium, co-payment, or deductible, and the payment of unreimbursed medical expenses.
And then, Madam Chair, pursuant to Ms. Murray's comments, we would include, or I think we should include, as part of that definition, the public assistance as appropriate insurance as well.
And this is Nova for the record. It's 303.31A2, health coverage. We clarify that health care coverage includes public and private insurance.
Under the comments of the federal regs? Is that what you're referencing?
I'm looking at, this is Nova Murray for the record. It just says section 303.31. It looks like it's not a comment. It's actually part of the reg, and they're just summarizing what was changed for us. So I'm on
What page of the federal?
I'm right here.
93499?
And then it's right here in the middle of the page.
Madam Chair, Keith Pickard for the record. Before we go down that option path, just with respect to the cash payment issue, as I read this, because this is a qualification, sub A is a qualification of sub 1 above it, I see this as already incorporated the concept of cash. I don't know that we need to put that in both places, but maybe I'm reading it wrong.
I would agree. I felt repetitive when I got all the way through that sentence, when it goes back down to talking about payments. But I think what we can do right now is that if Dawn has some direction to work off of the information in the Federal Register, which we are finding, as we stated on page 93499 of the final rule from the feds, and make sure, read that medical information and make sure it's incorporated accurately, and that with the concept that we need to have public and private insurance be contemplated within any of the language we have, and then come back to us and we'll make sure we're all on the same page. And whatever else we have in Nevada statutes regarding this definition, make sure it's incorporated, then we'll be on the right page and have everything because I think the general consensus, right, is one, it needs to include private and public health insurance, no matter what, at the end of the day, and be consistent throughout the different spots that we have medical definitions to make sure we're covered. And add the specific findings requirement for a deviation of the medical cost being 50-50. Those are the things that we need to incorporate into there, Dawn. And is that a good summary of everything we just discussed on that? Did I miss anything? Those were my notes on that. Okay. All right. We just knocked out another agenda item. Congratulations, committee. We're getting closer to being ready for the new year.
This Dawn Throne, can
Yes.
we have one thing on that subsection C, where it says the obligation for support shall include the cost of providing medical insurance. Should we clarify in addition to the percentage above? So we're building. Here's the base amount. We're building and adding medical insurance or medical support on there. And then we got to decide if we're adding child care too.
This is Bridget Robb. John, can we solve that problem by simply saying the obligation for support shall also include? Or shall
Sounds good to me.
include as an addition?
Yes, I think that helps.
Dawn, do you need any additional direction on working on the medical section before we move on?
No, I think I got it.
Okay, so far I've got that I will rework the incarceration language. Dawn's going to rework the medical language. Judge Hoskin is going to create the definition of what support is for. Nova is going to collect or figure out a way to give us childcare information. There was something that you were still going to rework, Judge Robb. Am I right?
Yes, and it is in the language of the deviations.
Deviation changes.
Correct. We were adding in an additional deviation to sub 6 with regard to domestic violence directly related to relocation.
Okay.
And transportation costs associated therewith.
Okay. So we're getting our homework
Adjustment.
list together here.
Adjustment, not deviation.
Adjustment.
Thank you,
yes.
Assemblyman.
We want to stay away
Correct.
from that
That is
word.
correct.
Ay, silliness. Okay. Tomato, yes. All right.
Madam Chair?
Yes, ma'am.
Dawn Throne. To go back to where we were talking about if we're using the USDA figures for child rearing. What does that include? What does that not include? I don't think we finished that discussion of page 25 and 27 of the report.
To help Judge Hoskin in his definition of what support is?
Well, also to consider, should we be adding the medical support? Should we be adding childcare when those are in what is the 7 expenditure categories, according to page 25? Includes food, transportation, housing, clothing, health care, child care, and education, and miscellaneous expenses.
Yeah, I'm pretty sure that was that point in page 27 that our number did not include
Didn't include either childcare or the health care. I can't remember
one or
which.
the other. Which one, Joe?
It's childcare and education expenses. Childcare and education expenses were excluded from the USDA numbers as they were shown in our graphical representations compared with the 17%. And that's on page 17 or 27. And then I believe that on page 25 it describes how there was, the USDA numbers, they have numbers for childcare and education, but as it was displayed for our use in exhibits 14, 15, 16, all the way to 21, the upper bound number of the USDA excluded those expenses.
So my recollection on the childcare, at least, was that we were going to wait to see how our percentages play out in some calculations. Well, we were going to wait till we obtained some data from Ms. Murray about the average cost of childcare in Nevada, and look at that in terms of our calculations and see how that plays out together before we make a decision on whether or not we leave it as a deviation factor versus a set calculation in here, or if we bake it into the percentages, or if it's already baked into our percentages. Because childcare is higher than the cost of raising children.
In the graphs.
In the graphs, according to Ms. Murray, yes. So we're still waiting for some of that data to see where we go with that. But we can start the language and go from there. And once we get that child care information, I think it'll help us. Plus, I think to kind of go back to 4A on the base calculations, as a committee, as a commission, we need to be prepared at the next meeting to have really sat down maybe and run through some scenarios and done the math on this with including the higher income numbers, and compare that to the USDA data that we've received and see how we feel about our percentages and how they're sitting and how they're playing out with real calculations or fake calculations, but some hypotheticals, and go through that and have a good gut on it, because I think honestly it's sitting here, it's in front of us, it's the percentages that we have the additional changes from Wisconsin, but whether or not any of us feel like that's still based on Nevada's USDA numbers or not, and coming out properly or not, is something we need to contemplate. Once we have a good gut on all of this, then we are much better off to move on to our other agenda items, discussing shared parenting time, serial parenting. What was the other one? Well, additional dependence is really a big part of that discussion. But the split families circumstances. Okay. What
Madam
other?
Chair, can
Yes.
I ask a question? Something that's come up recently in my practice is a question of what constitutes income. We've not discussed it before. but the first provision under 125B080 talks about income from all sources. Is there any appetite to also try to define what income is for purposes of
We need to look-
calculating child support?
Yeah, we need to look at the original bill because I believe the definition of income was left intact and not part of our,
Madam Chair, my recollection is the definition of income was altered, but was set by the legislature. I'm not sure that's in our purview.
I don't think it was altered. It was altered in terms of when they went to delete out the, to determine the sections they were going to delete out to put within our purview, they had to reinsert the definition of income into a prior, a statute that was earlier in the chapter because it would have deleted that out. Hold on, let me look at the bill. I'm talking, I could actually be giving actual.
Madam Chair, if you look at page 5 and 6 of the bill, it's in section 12. I think that's where income is defined.
Right, and that was, but that was just moved language. It wasn't actually modified. Because it got deleted out, because 125B070 is being deleted by our work, they took the definition from 070 and relocated it there instead of saying it has the meaning ascribed to it in 070. Because it's no longer in 070, so they took the definition and stuck it there. That's order of support, though. So on page 5 of the bill, under what statute is that under at that point?
This is section 1
So-
of maybe 278.
It is section 1,
addresses.
and it's modifying
125.150.
125.150. That's what I was looking for.
Right, so that's the alimony statute.
Right, and so they took there and they dropped in, instead of referencing back to 070, they dropped in the definition of income there. And then, did they do it again? No.
This is Nova for the record. In that instance, we wanted to try to get it moved into a more appropriate place, like a definition, because it seems unusual to go hunting through a regulation that
Alimony
has nothing
statute.
to do with this. So I would hope that through this process, we would move it, but, and/or add it somewhere so that it was easy to access, but it doesn't look like we have the ability to change it.
Again, Keith Picker for the record. As I recall, we moved it into the, under section 12 of the bill, we moved it into 125.150 because otherwise we would have lost the definition of income altogether. And so the purposes, or the purpose of sub 12 under section 1 was simply to provide guidance to the court for what is to be included in income for purposes of alimony. I don't think that has anything to do with us. I think we still, if we want to mirror that, fine, but I think we do still need to address the definition under 125B080 because ultimately that section goes away in its entirety when we adopt our regulations.
I agree. I think because within 150, we would have been stuck with alimony not having a definition of income. But that does not
At all,
mean.
right.
At all, right. That does not mean that we don't have the ability to give child support still a definition. It needs a definition of income. It can't be without.
And that's my point.
And that's what if we don't do one, that's the net result of the way the statutes are written, is that there will be no definition of income if we don't put one back in.
And that's the way I read it. And so that was my concern. And it came up because
Agreed.
some of the departments down south are defining income so broadly as to be any cash flow, regardless of its source. And I think that is a mistake. We have an opportunity to maybe define it more precisely.
Okay,
and
so
I can
what,
go
here, let me
into-
jump in real quick. Let's put us under
Sure.
an agenda item to make sure we're in compliance. And the AG's office is happy with
Well,
us.
I believe that this would still fall under the recommendations
4A.
for the formula.
And then perhaps on a future agenda, I can make it a little more specific that we're going to address that individually. But I agree, it does fit under
And that-
4A.
That's fine. I didn't mean to necessarily open this up for discussion today. It was just a concern that came up, that I went back and looked at this, and I thought this is a good time to bring that up. So, Madam Chair, if you'd like, I can address that more fully at our next meeting.
Yes, with proposed language.
I can do that.
Great, we have
This-
lots of
this
homework
Dawn Throne,
happening.
If I can weigh in on that, I think we need to look at the legislature also amended 125B 145 regarding modifications to specifically, if you look on page 8, adopt the 125 150 gross monthly income. So for modification, they did define gross monthly income as the same as the alimony statute. Should we make it match or be different is another question.
And they only, yeah, that was more of a drafting error, I think, that we didn't think through this.
We actually did think through it, but it was too late because the drafting is done by LCB. And
Yeah.
it was a little too late when we came in and noticed how funky it looked. So there's no problem putting in a definition. It just didn't happen that way.
Where's that modification language, Dawn, that you just pointed out? It's on page 8.
Page 8
Oh,
of the
right
bill.
down there. Okay.
And Madam Chair, the language I have in mind, well, I shouldn't put it that way. I don't have it fully formulated, but the idea in mind is merely to clarify, not to deviate from the idea that's expressed now in 125B, or I'm sorry, 125-150, because frankly, the issue came from the interpretation of income from any source. And I think that we can tighten that up in our regs with respect to child support. It won't conflict per se with the broader definition. It'll just be more specific. And then we can, in the next legislative session, go in and tweak 150 to match so that it's clear in both instances.
Okay, great. And that would include or not include some of the discussion about SSI? Do we want to incorporate that or just leave it in that deviation factor that we have right now?
My understanding is SSI is under federal law and preempts us. We can't touch it.
Right, so we have it as a deviation factor. SSD, I'm so sick right now, I feel, I'm trying. SSD, we have in the deviation factors, which I think is worth a discussion right now. So we'll go back to our agenda item on the deviations about the Social Security benefits available to the child as a result of Social Security disability payments received by the payer parent, but not a result of the Social Security disability payments received by the payee parent. Does that become a part of any of our definition of income, or is it just better off right here as a deviation factor? Or what isn't income, et cetera?
Nova Murray, for the record, I believe it's included as a form of income
But the benefit for the child is not because that's the
because it's the
child's.
deviation.
Right.
Keith Pickard for the record. I don't know that we need to decide right now where that goes. Let's, because I can see it going in a couple of different places, why don't we decide that after we decide the language?
Deal. Okay, I like it. And then I was starting to go down a road on another agenda item, and because I feel so wonderful, I don't remember where I was with it. I was going to recommend that we talk a little bit about
I don't think you'd get any objections if you went straight to 14.
wonderful. 13. Way to confuse me. Well, we have to go to 12 first. And let's talk about, 11, we have another meeting set for, our next meeting is set for January 17th.
And one of our dates got kicked out of here. Which meeting got kicked out? Of January's meeting got kicked out of
So-
LCB, or was it a February meeting that got kicked out of here? But we don't have
So
this
our
here.
January meeting we got kicked out of LCB, so we're pending a location for the January 17th meeting. So most likely be the same locations as the last meeting at the universities. Okay.
Do we need recording capability or just video conferencing? Because for that matter, we could go to my office. I have video conferencing available.
We need recording. Yeah,
Okay,
it has
well,
to
then
be
I can help you.
recorded for public meeting purposes. Okay, so we will, then the location, it'll still be determined in the future. Is there
Just-
any possibility of us getting the LCB buildings or no? Not for the 17th at all? Okay. Yes, Mr. Sanford?
And this is Joe Sanford for the record. As far as the recording, the video doesn't have to be recorded. It's only the audio that needs recording.
Correct.
If that makes it easier for you, Mr. Bickard.
Judge Hoskin just suggested we could do it at the courthouse as well. And they do have a bigger conference room than I do.
Well, the courts are always a possibility, and the Supreme Court's a possibility too, because they've got some conferencing abilities too.
Nova
but-
Murray, for the record, we also have that in our office. We can
Okay.
use our locations too. We record video and audio.
So I think the only reason I'm bringing it up is since the format of the recording last time was a problem for you, I hate to go down that path again. We'll figure it out. We'll figure it out by then, but at least we have some opportunity. But our next meeting that was scheduled previously is still intact and will still be a good date. So we can move on to, let's do agenda item number 10. Does anybody have anything else they want me to tweak or add for future agenda items that was not already discussed?
Judge Hoskin, I'm just trying to get some clarification. Is Judge Robb going to be the keeper of the language, and we're all forwarding it to her to incorporate in the stuff that we're going to be adding between now and the next meeting? Or how's your thoughts with regard to?
I'm looking at Judge Robb to find out the answer
Oh.
to that.
Sorry, Judge Robb.
It's Judge Robin, I'm happy to
I'm
be
just-
I'm happy to be the clearinghouse.
That'd be great, because it helps me if I can see it all together and kind of see how it interplays rather than getting bits and pieces from everything else.
I agree. Thank you. I'll do it.
I agree. So I'll provide the incarceration language, and each person that was designated to do something, provide it to Judge Robb. She'll get it into one document. Then it'll be posted on the website as one document, one changing, evolving document that we're working on. And it'll be good for us as a committee. The other thing we probably should look at is some of our prior decisions that we've made that maybe haven't been incorporated in there yet that we may. I don't think there's too many of them, but I need to look over old agenda meeting minutes. Ms. Murray?
Completely unrelated. We have on the website, and I don't know if everybody's familiar with this, but I will give this to the public as well as to the committee. On the dwss.nv.gov, under child support, we have the Guideline Committee. We have all of the agendas in order. We have a link to all of the meeting minutes as well as the meeting videos, except this last one. And that will be ever-changing so the public can see all of those pieces. We have a quick reference to it because it's also in the public meeting section on the welfare website. This is outside of that. It's a special place that has been set up so you can see everything at a glance. It's got our information, our contact information, kind of from the inception. Staff worked on that pretty hard, so everything's out there for the public as well as the committee.
Okay, and as far as future agenda items and the committee working on their individual language, don't forget the public comment that has been submitted in writing, and take a look back on that in case you can get any ideas or assistance from that, so that we're definitely taking that into consideration. Let's move on to agenda item number 12, public comment. Is there anybody in Las Vegas that would like to give public comment? Seeing none, is there, oh, never mind. I take that back. I can't see the room, sir, so I had to wait till the camera switched. Go ahead. Okay, sir, so that you know, the public comment is restricted to 3 minutes. I will be rude and completely cut you off at 3 minutes so we can move on. If you could please give your name first, and if it's a difficult name, if you could spell it for us so that we have that. And then I will start the timer, and you have a button in front of you for the mic that if you could turn it on, then we can hear you, and you can go ahead.
My name is Deleon Jones. That's D-E-L-E-O-N. Last name Jones, and I promise I won't make you mad. I came here today to talk about how when fathers or even mothers, when they're incarcerated, how the cost of their payment for child support keeps drumming up, and how are they supposed to pay for that when getting out? It's difficult to get a job. It's difficult and also having their license taken away. That's difficult for them to travel around to look for a job, or to do training, or to even go back and forth to see the child. And I was just wondering, is there someone who can give me some insight on what would it take for a father or mother to get some help to cut the cost of those payments? Because when they get out, some have low education, and it's hard for them to get a job to begin with, and then that steers them back into a danger zone. So I think in my side, it defeats the purpose when the cost is built up. It makes them fearful, and it runs them scared, like they just have to accommodate that cost. And is there a way to kind of cut the cost, to give them a peace of mind, is what I'm asking. And furthermore, what would it take not to have their license removed?
Okay, thank you, sir. If you'll remain there for a moment, do any of the committee members have any questions for him?
Excuse me.
Seeing no questions. Sir, thank you for your time. We sure appreciate it. We are taking a look at the language surrounding incarceration and child support, and we will look into that in terms of driver's licenses and the enforcement methods and procedures. That is not within the purview of this committee. The legislature did not give us authority over that. But in terms of what child support is during incarceration, that is something that we are working on, and we appreciate your time today. Thank you.
Well, thank you for listening to me also. I didn't make you mad either, so I'm happy.
You didn't make me mad. That would take a lot of work. Is there anybody else in Las Vegas that would like to give public comment? You can come forward. Okay, I'm sure you heard me already state public comments limited to 3 minutes. I will be rude and cut you off, unfortunately. But if you could give your name and spell it if it's a difficult name, and I will start your timer after you begin your public comment, or after you give us your name.
Hi, my name is Sarah Gisela. My first question is the redraft for 125B0701F. When is this going to be implemented?
Well, ma'am,
Madam
this
Chair,
is...
I can take the questions offline.
Okay, thank you. Yeah, this is more of public comment, not question and answer. But if
Yes, I
you
know.
if you would take a look at the original bill that was passed, which is AB 278 from this last session, it gives the implementation process, and our report is due by July. And well, I can't tell you when it'll actually become effective and go through all of its government procedures at that point, but.
I have a question again, not a comment.
Okay, well, the committee members that are in Las Vegas, in particular, Assemblyman Pickard has just volunteered that if you have questions, he's happy to work with you after we close out the meeting and answer your
All
questions.
right, thank you so much then.
You're welcome.
Thank you.
If you have any public comment to give us or things you'd like us to consider, we're happy to listen. Okay. Anybody else?
One more comment.
All right, Mr. McDonald, do you know the procedure?
Sorry, there's a microphone. I would like to make one more comment in regards to some of the items discussed today. In regards to personal experiences, I've experienced almost every aspect of the family court personally, the hard way. So one thing is that I did used to do reports for city council as I worked for the city of Las Vegas. I would like to present you guys a report, which I'll email to that in regards to how Sweden's laws under Erwin Garfunkel, he's one of the experts in this area of how they set their child support and their custody enforcement. I want to tell you guys a story as also one of the reasons I'm so adamant about getting the child support laws is because me and my ex fought me for joint physical custody, as she only agreed to 38% of the time. She wouldn't agree to the 40%, as she used to be a paralegal. I got put in jail for 6 months for trying to call my own children. I got thrown in jail. I've never been in jail before. I didn't have any criminal record. As soon as I got thrown in, it was all about the money. It's insane. I get while I was in there, it was accruing each month. The payments were accruing, almost $1,500 a month. When I got out, I get a call from the DA saying you owe $14,000, and they're trying to take my license away. I did get a thing through the DA, or my mom got an attorney that got the modification to $200 a month since I have 2 children. Now, part of that it was set to the 200, and it was. But the DA and the family court do not talk to each other. So that's one of the things I would ask that you guys address too. There's no communications. They don't know what orders are from what court. They don't see each other. They don't speak to each other. So I'd ask that you guys put that piece. Like I said, when my house got sold, they said I owed $14,000 in arrears. The judge put in an order for the arrears, and they took it out of the forcible sale of my house, even though I had a refi approved. My house got sold illegally without me signing it. I had a refi approved. Everything was in place. I lose my job. I had a good job. You guys don't understand the effects that you're having on so many litigants and so many people that I work with every day. They lose their whole lives. They go to jail. They can't see. I haven't seen my own children in a year since last Christmas. Like you can't understand the effects, the soul ripping effects that so many people are that they can't see their own children. They can't, and it's all because of money. If there was a set standard, that my ex wouldn't have fought me for that. I'm a good dad. I love my kids. I take care of them. I pay for them as much as possible. But to get thrown in jail, to go to all this system because of money, it's you guys don't understand the effect, the far-reaching implications of this, and then not any enforcement of parental involvement or seeing your children too. So please take a look at that. Work with the DA that's
Okay.
going to
Thank
set
you,
standards.
Mr.
So
McDonald.
thank you.
I appreciate it.
All right, thanks.
We appreciate your time.
All right,
and-
sorry. I'll be more prepared, and I'll send you that report through your
Okay.
email. So thank you.
We appreciate that. Thank you. Is there anybody else in Las Vegas that would like to give public comment?
None here.
None, no more? Okay. Thank you. Anybody on the phone that would like to give public comment? Hearing none. Anybody in Carson City that would like to give public comment? Come on forward, sir. And you've heard the spiel about 3 minutes and the button and all the fun stuff, yes. And, ooh.
My name is Bryce White, and first of all, I'd like to say thank you to all of you here working on this extremely important topic, well overdue, and thank you also to the people who are not here. Just a little bit smaller thank you to those people that are not here, but I appreciate all of your efforts. I'd just like to say I would like you to consider, I respectfully disagree with Mr. Sanford on the idea that high arrears equals low collection. It's no cause and effect there in that case, even though statistically it may be that, people that owe a lot, you're unable to collect from them very often, but there's a whole myriad of reasons other than just high arrears why those persons might not pay. And to dismiss them because statistically they don't pay, so why collect is, to me, kind of an absurd idea. The other thing I would like to say is that I agree with Ms. Murray about the transportation deviation. It seems like I would like you to consider not having a transportation deviation. And my rationale there is that if all the people that have joint custody can do it, I mean, your discussion was mostly about people who are primary and non-custodial parents. You didn't discuss what happens to people with custodial, with shared parenting. And so in that case, if shared parenting people can manage to stay in town and find a job in town so they can be with their children, then a non-custodial parent can also find a job in town. And if their work is so specialized that they cannot find a job in town, then I would say they're not in the low-income bracket and they can afford to bear the expense of going to visit their children. Also, want to go back to the thought of dismissing the obligation while you're incarcerated, because most of that discussion was only about if it's a primary and non-custodial parent. If it's a shared parenting, it might be appropriate to adjust custody or to adjust child support upwards because somebody's been incarcerated because they are unable to perform the child care obligation that they've signed up to. If they have 40% custody and they become incarcerated, now they have not only dismissed from any amount that they have to give monetary, but the added burden of their percentage of care is added to the person who didn't commit a crime. So I want you to consider that in
You're at
part of
3
your
minutes.
discussions.
Thank you, sir. I
Thank you
appreciate
very
it.
much.
And Mr. White, if you'll remain for a moment, is there anybody on the committee that would like to ask any questions of Mr. White? And I'll clarify, you presented the written public comment to us at our last meeting, the 3 different pieces, correct? And one of them was on incarceration, just to point out to the committee so that they know, put a face to paper, and know that you have those materials in your hands. One was incarceration, one was shared parenting, and the third one, help me, was?
Got me on the spot now.
Was here. We have it.
Yeah, I know you do. I saw it in your here.
Okay. But we have it. And I know one of them was about incarceration, just since we cut you off on that. Okay. Thank you, sir. I appreciate your time. Thank you. Would anybody else in Carson City like to give public comment? Okay. Seeing none, I will entertain a motion to adjourn.
So moved.
So moved.
Second?
Second.
All in favor? Aye.
Aye.
I assume no one's opposed. Happy New Year. and we will see you in the new year. Thank you.